By any objective standard, we are living through a turning point in the history of this country. For nearly 4 years, we have watched as what was once unthinkable, white supremacists with torches, children in cages, armed mobs storming state houses, has become normal. And now we're speeding towards an election that Donald Trump is already contesting. Today, we're going to take a look at the role of the courts and the judges that Donald Trump has appointed in all of what's afoot, and the implications of what's going on in the courts for the future lives of millions in this country and the country as a whole. So I am very delighted to have with us to discuss this somebody whose columns I've read and learned from for many years. Linda Greenhouse is a Pulitzer Prize-winning journalist. She covered the Supreme Court from 1978 to 2008 for the New York Times. Now she writes a biweekly opinion column on law for the Times, and she is also the distinguished journalist in residence at Yale University. She's the author of many books, including Before Roe v. Wade, Voices That Shaped the Abortion Debate Before the Supreme Court's Ruling, and most recently a memoir, Just a Journalist, Reflections on the Press, Life, and the Spaces Between. Linda, I am so happy to welcome you to the RNL, The Revolution Nothing Less show.
It's a pleasure.
Great. So listen, I want to start with the question of abortion. And I wanted to ask you, for people who are not following the courts, maybe not paying that much attention, maybe taking women's right to abortion for granted, could you give us a sense of where this right is at legally, and what is the future of anti-abortion laws?
Yeah, so, for a generation now, Republican presidents have made it a point. In fact, they've been obliged, running on the Republican Party platform, to appoint judges who oppose the right to abortion and who would, the presidents believe, overturn Roe versus Wade if they had a chance to do that. And I think the fact is that there are now 5, this has been a very successful project. So there are now 5 justices on the U.S. Supreme Court and a number of judges seated away on the lower courts where they can't overturn a direct Supreme Court precedent. So the action's all at the Supreme Court, who, if they could wave a magic wand without political consequences and with the right case and so on, would overturn the right to abortion in a heartbeat. The only thing that stands between that and now, well, one thing that stands between it, I think, is Election Day. A friend of mine once said, Roe against Wade is the gift that keeps on giving to the Republican Party. As long as it's there, it's something to mobilize around, even though poll after poll, including polls before Roe against Wade and ever since, show that a majority of the American public, men and women, want to keep the right to abortion available. So it would be pretty politically damaging for 5 hand-picked Supreme Court justices to vote to overturn this precedent that has stayed on the books since 1973, modified along the way, you might say weakened along the way, but it's still there. So the current law of abortion is that states may require women to jump through all kinds of hoops. They may require women to get mandatory counseling, which doesn't necessarily tell them the truth. They can require waiting periods. They can require all kinds of obstacles. But at the end of the day, if the woman persists, she cannot be stopped from exercising her constitutional right to abortion. So where the rubber's meeting the road right now in a series of cases is, how high can those obstacles be before they become, the legal term is, an undue burden on the right to abortion. That's the current standard, the undue burden. So what is an undue burden? And the states and the anti-abortion movement is testing that every day.
I'd like to ask you from your own life experience as well. You've obviously covered the courts and the legal decisions, but now you're an opinion writer and you have an opinion. You're a very vocal advocate for women's legal right to abortion. What is your sense of the impact on women's lives? Why is that so essential? Why does that matter? And what is a world like when women don't have access and they don't have that right. I know you came of age before the right to abortion, and I think it's something young people don't have any idea what that really would mean.
Right. Yeah. I mean, I graduated from college in 1968. Seems like a whole long time ago. And of course, Roe against Wade was not until 1973. And no, I knew, I mean, even in high school, there was, I remember a girl in my gym class who one day just disappeared, never seen again. She had become pregnant. She had to have a baby. She dropped out of school. I mean, what's really going on here, it's not about the fetus. It's really not about the quote, right to life of the fetus. It's about the right to life of women to have the ability to control their lives without paying an enormous life-changing penalty if they happen to get pregnant and don't feel the ability at that time in their life to give adequate care to a child. It's about women's agency. And, I think what really brings this to the fore currently is what's called medication abortion, where you take 2 pills in sequence and you have an abortion. And it's only available in the first 10 weeks of pregnancy. And, people on the other side of the street really ought to be saying, that's great. We say we're really worried about these late abortions. But so here this enables women to have these early abortions. But instead, medication abortion has been the focus of enormous efforts to regulate and make it very difficult. Why? Because it gives women power. It gives women power to go to a doctor and say, please give me those pills. And you take the pills you're legally allowed to take the pills home and take them there and have your abortion there in the privacy of your own home, under your own control. And it's the need to control women that has always fueled the anti-abortion movement. One thing that's interesting, I'll mention kind of a footnote. So during the Food and Drug Administration, which regulates drugs, has permitted women to get the pills from the doctor and take them at home. But you have to go to the doctor. You can't pick up a prescription in the pharmacy. You can't get it by mail. You have to go to the doctor. Mm-hmm. So a bunch of medical organizations and groups of patients went to the Food and Drug Administration after the pandemic had started, saying, a lot of medical offices have closed. It's very difficult these days to leave home and get on public transportation and get to one. So we'd like you to temporarily change the rule and allow doctors to deliver or mail the pills. And the FDA said no. The FDA said no, even though they're allowing that for other regulated drugs, like a drug for multiple sclerosis, a drug for a certain kind of severe depression, where you used to have to go get it from the doctor. And now the doctor can send it to you, but not for the abortion pill, which is very safe. It's been used millions of times. It now accounts for, I think, 40% of all abortions. But it's what you might call abortion exceptionalism. The rules that apply to everything else are different for abortion. It's because it's about women's lives.
Another thing that brings this out is the concerted assault on birth control and the carving out of more and more space for religious institutions. And my understanding is, and maybe you could shed some light on this, even secular employers to deprive women of their right to birth control coverage in their health care coverage. This has also been working its way through the courts and intersects. I guess I'd like to hear your thoughts on that, as well as sort of the bigger question that's part of, which is the role of religion in public society and the separation of church and state. Yeah, go ahead.
Yeah, I mean, we are inching, makes it sound too slow. We are hurtling ever faster toward a kind of theocracy. It's very, very disturbing, and the Supreme Court is really enabling this. So the birth control is really a good example. So under the Affordable Care Act, Obamacare, there's a requirement that employers in their employee health plans provide for contraception coverage without a copay from the woman, from the female employee. And, that's the rule. And the Obama administration carved out actual churches from that. So the churches themselves don't have to do it, but all other employers had to do it. So this was challenged, excuse me, in a case people might have heard about called Hobby Lobby. So Hobby Lobby is a corporation. One didn't know that corporations had consciences or religion, but it's a privately owned corporation with thousands of employees, owned by a religious family. And they said, oh no, we can't do that. We can't abide by this because that would make us complicit in the sin of contraception if our employees avail themselves of this benefit. And there was a carve out required by the Supreme Court, and the Obama administration lived with it for closely held corporations like Hobby Lobby with religious objections that said, okay, the women still have to get it, but you don't have to provide it. You just have to notify us, and we'll tell your third-party insurer that their legal obligation is to cover it, and that'll be that. Not good enough for the religious groups. So the latest case, which was decided about 6 weeks ago by the Supreme Court, the Trump administration came in and said, okay, we don't have to jump through all these hoops. We don't have to make employers ask, notify, anything. If they want to opt out for religious or what they call moral reasons to not want to provide the coverage, that's okay. Just don't do it. And they didn't even define moral. They didn't set any limitations on it. Just, put your hand up and opt out of one of the basic requirements of civil society, which is we all live by the same rules. We all live by the same rules. And the court upheld that. A case called Little Sisters of the Poor. The court had 3 religion cases at the end of the term. That was one, and I'll just mention the third one, which was requiring states, if they provide any kind of tuition assistance for private schools, they have to do the same for religious schools. They have to do the same. And that really changed the law. The law had been previously, which I didn't approve of personally, that if you provide it for the non-religious schools, you may also provide it for the religious schools. The court changed the may into a must. They must. And that's a case that's going to have huge implications going forward, in part because, as we know, in different parts of the country, a lot of these private schools were started as segregation academies, as white-only schools when integration, which of course we know hasn't moved nearly far enough in the schools, but when integration came in, parents set up these little private schools, and many of them still exist, and they're under a religious umbrella, and they're going to be able to eat at the public trough now, and it's very disturbing.
You're making me very unsettled, Linda. You're making me even more unsettled than before we began this interview. Yeah.
As Michelle Obama said in her speech the other night, she said, you may not think things can get worse, but they can. So that's just an example.
Well, Linda, I really want to thank you for taking the time, for coming on the RNL, the Revolution Nothing Less show to talk with us. And I really hope that we can have you back sometime in the future.
Okay, you all take care.